Those of you who have been here before, and I see some familiar faces, get to listen to this one more time. Missoula Public Library Foundation is a sponsor of these forums, and the foundation has done a lot of wonderful things for the library over the years: purchase of equipment, funding in-service training for the staff, and out-of-town trips for staff people. The library is a better place because of what the foundation does. They are part of the Leave a Legacy program, so any of you who are interested in contributions, donations, charity, the Public Library Foundation is a very worthy cause. The flyers are back on the table. I encourage, if you haven't already picked one of these up, to do so before you leave this evening. Okay. This is the last program, and from my own biased point of view as a historian of 20th century America, which was my field of specialty in going to the University of Montana here many years ago, I have to say this is the program I look forward to the most. But as I say, that's my biased point of view. We've had some excellent speakers, certainly, and tonight certainly is no exception. Michael Mayer, who has been teaching 20th century, has it really been since 1988? I can't believe that, because I remember he is the person who succeeded my mentor in that position as the specialist in 20th century U.S. And it's hard for me to imagine that it's been 16 years since Bill Evans retired. Michael was born in Baltimore, Maryland. Earned his BA and his MA from Duke University and his doctorate from Princeton University. He has taught at Princeton, St. Vincent College, and the University of Alabama, and Auckland University, and the University of Illinois prior to coming to U of M in 1988. He is the author of Simon E. Soboleff, The Instructor's Manual to Accompany the American Nation. I'm getting through all these editions. Original and Secondary Sources. Michael Meyer edited and wrote the introduction and contributed an article on the Brown decision to the Eisenhower presidency. That's the title of the book. And another title called The 1950s, is that correct? He has also edited and wrote an introduction to Merrill Proudfoot, Diary of a Sit-In in 1990. His articles have appeared in the Journal of Southern History, Journal of Policy History, Congress and the Presidency, Australasian Journal of American Studies, and the New Zealand Journal of History. He contributed essays to Re-Examining the Eisenhower Presidency, Dwight D. Eisenhower, Soldier, President, and Statesman, American Political Trials, and Law and the Great Plains. So as you can see by that resume, he is eminently qualified to speak on the topic that we're addressing this evening. In fact, he was so excited when I was talking to him on the phone about this that he didn't realize I was at a public desk. So, but we chatted for about 15 or 20 minutes. It's just nice to have someone so enthusiastic about a topic. The title of this evening's talk: How Separate Became Inherently Unequal. Brown versus Board of Education. Michael Mayer.
As you just heard, the subject of my talk tonight is how separate became inherently unequal, and obviously that's a long story. But before we talk about that story, I think it's important to consider how separate but equal came to be. It did not, as most people imagine, spring up full-blown at the end of the Civil War. The idea of separate but equal evolved gradually over the course of a generation. With the end of the Civil War came the end of slavery, and the victorious North passed 3 amendments to the Constitution, the 13th 14th and 15th Amendment. The 13th Amendment ended slavery. The 14th Amendment made everyone born in the United States or naturalized citizens, and it contained the three great clauses: the Privileges and Immunities Clause, the Due Process Clause, the Equal Protection Clause, important guarantees for all Americans. The 15th Amendment prohibited interfering with the right to vote on the basis of race, color, or previous condition of servitude. Those three amendments were specifically intended to destroy the South's social and economic system. And to a certain extent, they were successful. But what would emerge to replace the existing social and economic system of slavery? People tend to forget that slavery was both an economic system and an arrangement of the races. The economic system of slavery was replaced with sharecropping and the crop lien system. If anyone has any questions about that, I'll be glad to talk about that later on. But that was an expedient. It was a system that had a long-term and very deleterious effect on the Southern economy. It was not, as many people suggest, a conspiracy of a few evil people. It was simply an attempt to put land and labor together in a society where there was no cash. But the social system of the South was even harder to reconstruct, and it took more time to evolve. You have to realize that segregation did not exist within slavery. Segregation was impossible within slavery. Slavery demanded very close interaction, very close contact between the two races. Close, intimate, and physically intimate relations, people living, working next to each other, were necessary for the supervision of slaves, for the maintenance of order, and for the extraction of labor. The immediate response to the end of slavery in the South was a withdrawal from this physical intimacy that had existed within slavery. And both races withdrew. Whites withdrew from blacks, blacks withdrew from whites. And the best example, I think, is the decision on the part of African Americans to leave the white Protestant churches and form their own churches where they could worship in their own way with dignity and without white supervision. Relatively early on in this process, most Southern whites concluded that whatever the new order was going to be, the maintenance of white supremacy would require a greater degree of physical separation of the races than had existed before. The first attempt to reestablish white supremacy was the passage of a series of black codes in southern states. Southern legislatures passed laws that attempted to reduce freed slaves to the position of legal peonage. They tried to make them peons, bound to the land, bound by service to whoever owned the land. Reconstruction wiped out those black codes, but it left open the question of Southern social relations. Some aspects of segregation appeared fairly early on. 3 states in the early 1870s adopted segregation on railroad cars. Schools were segregated throughout the South, almost without exception. There were a few exceptions, but almost without exception. Jails, hospitals, asylums in the South were all segregated. But Jim Crow, the term that's used to describe the system of disfranchisement, the denial of political rights, and segregation, the physical separation of the two races, did not spring up immediately. The patterns were uneven. Some places, like South Carolina, had fairly extensive segregation pretty early on. But in most other places, race relations did not crystallize during Reconstruction. And they didn't crystallize immediately after Reconstruction in the era that Southerners refer to as redemption, or in other words, the restoration of Southern white home rule. Even in Mississippi, as late as the 1880s, most saloons served both blacks and whites, and many restaurants served black and white customers, although not at the same tables. Don't get me wrong, this was not a golden period of race relations in the South, but it was a period of instability. It was a period of cross-currents and eddies. It was a period after the past, slavery, and yet before the future, Jim Crow. It was a period when decisions were made. More than a decade passed after the end of Reconstruction before the first Jim Crow laws were passed. And I think several factors contributed to the emergence of this new system of segregation and denial of political rights in the South. By the 1880s, frankly, the North was tired of policing the South. They fought a war, they'd been policing the South for the better part of 20 years, and they were just growing tired. Second, there was an element of sectional reconciliation as the two sections began to bind up the wounds of the Civil War and become a single nation. Not just again, but in a way that they hadn't before. I think the best indication of that reconciliation is the fact that in the 1880s, you see the Grand Army of the Republic, that was the Union Veterans Organization, inviting Confederate generals as well as Union generals to their meetings. Now that didn't happen in the 1870s, decade after of enormous bloodletting. Another factor was the rise of racism in the North. Beginning with the early 1880s, there were floods of immigrants from Southern and Eastern Europe to northern cities, people of different religions, Catholics and Jews, and Northerners regarded these as people of different races, and they didn't much like them. They didn't want to have a great deal to do with them. And these attitudes kind of played over. They thought, well, maybe the South was right all along. I mean, they didn't want to deal a lot with blacks. We're not too crazy about Italians. Maybe the South was right. Maybe we should let them organize their own society. There was also the rise in the late 19th century of scientific racism, racial theories about the supremacy of the white race, the inferiority of other races, and this led to the pseudoscience of eugenics and the breeding of human populations. Finally, a series of decisions by the Supreme Court in the 1870s and 80s narrowed the interpretation of the 14th Amendment so that if Congress or the President had been more interested in policing the South, in maintaining equality, it would have been very difficult to do so, but it almost didn't matter because neither Congress nor the Presidents were very interested in doing that. So given this background, beginning in 1890, every Southern state passed a new constitution. Within a decade, every Southern state had a new constitution. And these new constitutions disfranchised African Americans, denied political rights to African Americans, and established legal segregation, physical separation of the races. The first test of these new laws in federal courts was Plessy versus Ferguson in 1896. Plessy was actually simply a test of the Louisiana Public Accommodations Act of 1890. That act required separate railroad cars in intrastate travel within Louisiana, for black and white passengers. The railroads didn't much like it. The black community, it's very expensive. You have one black passenger, you had to add a whole car. The black community of New Orleans, which was large, relatively affluent, also wanted to challenge it, and so they arranged a test case. Homer Plessy, who was only 1/8 black and who could easily have passed for white, got into a first-class car, and as it was arranged, the conductor asked him to move. He brought suit against the judge who enforced the law against him, asking that this law be declared unconstitutional. The Supreme Court in Plessy ruled that the Louisiana Public Accommodations Act was a reasonable exercise of the state's police power. Now, when they talk about police power, it doesn't have a lot to do with cops and badges and guns and so on. It's the right to organize your own internal society. And it didn't say separate but equal. It just said that the Louisiana Public Accommodations Law was a reasonable exercise of the state's police power. But the logic that emerged from Plessy was separate but equal. And so there you have the evolution of Jim Crow, separate but equal. And in a series of cases, the Supreme Court, without ever directly doing so until the 1920s, applied the separate but equal rule to public schools. The late 19th and early 20th centuries marked a low point in post-Civil War race relations. That was the period of the establishment of legal segregation, disfranchisement, and it was also the peak period of racial violence as the white South resorted to violence to impose white supremacy. It's also the period where the new system that emerged in the South was accepted by the nation as a whole. In 1896, this new system won the seal of approval from the Supreme Court. After a race riot in Springfield, Illinois, the home of Abraham Lincoln, in 1908, a group of white leftists sent out a call for a conference on race relations, and out of this conference grew a new organization, the NAACP, the National Association for the Advancement of Colored People. From its inception, the NAACP focused on legal change and what they like to call education. I think some people might call it propaganda. And they had some early successes. In 1915, they got Oklahoma's grandfather clause declared unconstitutional. In 1917, they got mandated residential segregation in St. Louis declared unconstitutional. But these decisions had very little impact on the larger edifice of segregation. And with the coming of the Great Depression in 1929 and 1930, many African Americans began to criticize the NAACP for its focus on civil rights. They said that given the economics of the era, they should be talking about food and clothing and shelter and taking relief agencies and this sort of thing. In response to that criticism, Nathan Margold, a white lawyer who did a lot of the NAACP's legal work and who directed the NAACP's legal campaign, produced a report. And in it, he maintained that without agitation for equality, for civil rights, it would be impossible to expect fair treatment from government relief agencies and so on. He also suggested in that report a focus. He argued that unequal school funding violated the 14th Amendment and the requirement under Plessy of separate but equal. And he proposed holding the South accountable to the equal part of the separate but equal equation. It was an interesting strategy. He didn't stay around to do much in the way of implementing it because in 1933 he took a job with the New Deal. Up to this point, white lawyers, Moorfield Story and Nathan Margold, had handled almost all of the NAACP's legal business. But when Walter White, the executive director of the NAACP, looked around for someone to replace Margold, he selected Charles Hamilton Houston, who was a truly extraordinary figure. He's not very well known. I suspect many of you may never have heard of him. But he was perhaps the most important black leader of the first half of the 20th century. You could make a case for A. Philip Randolph or W.B. Du Bois. But in terms of actual accomplishment, I think you can make the best case for Houston. The reason he's not well known is partly because he functioned behind the scenes and he was the rare selfless individual who put other people forward, gave them the center of attention and advanced their careers. The appointment of Houston cemented what were already close ties between the NAACP and Howard University's law school. Howard University was founded after the Civil War essentially to educate freed slaves, although it was open to all people of all races. It was named after Oliver O. Howard, one of the least successful of all Union generals and the first president of the new institution. And into the 1920s, Howard was a mishmash of secondary school, college, vocational courses. Only, to give you an idea, only the medical and dental schools were actually accredited. And it was pretty much a high school, more or less. In 1926, though, Mordecai Johnson became the first black president of Howard University. And he adopted a time-honored and very effective strategy of building a university. He went out and found the best black scholars in a variety of fields, hired them, and allowed them to build departments. He hired E. Franklin Frazier, a sociologist, Ralph Bunch in political science, Rayford Logan and Benjamin Quarles in history, Edward Everett Just in biology, and Charles Drew in medicine. Drew, some of you may know, was one of the people who was important in isolating plasma from whole blood so that it could be stored more effectively. But when Johnson took over the law school, was a joke. And just as he'd done with all the academic departments, he looked around for someone to lead the law school in a different direction, to remake it. And he didn't need to look very far because Charles Houston was teaching part-time on the faculty at Howard. In 1929, Houston took over as dean of Howard Law School. He was 34 years old. He's a fascinating figure. His father was a successful lawyer in Washington, D.C. He was educated in the public schools of Washington. He was his high school valedictorian. He graduated Phi Beta Kappa from Amherst and then went to Harvard Law School, where he was the first black on the Harvard Law Review. He graduated from Harvard Law School in the top 5% of his class, stayed on to get a doctor of juridical science with Felix Frankfurter, then won the Sheldon Traveling Fellowship and went to Spain and took a doctor of civil laws from the University of Madrid. After all of this, he went back and joined his father's practice, Houston & Houston, in Washington, D.C., and taught part-time at Howard. In the 6 years he was dean, Houston built a serious law school. He raised admission standards. He expanded the holdings of the library. He raised standards for students. Often only 1/3 of the entering class graduated. He brought in the best young black lawyers in the country to teach. William Hastie was one, his second cousin, who also had a BA from Amherst, who was also Phi Beta Kappa, who also went to Harvard Law School and also wrote on the Harvard Law Review. And then he went to work with Houston and later got his DJS from Harvard. Another faculty member was Leon Ransom, who graduated #1 in his class at Ohio State. You don't think that was an interesting trick for an African American in the 1920s? Think again. James Neighbor was another graduate of Northwestern Law School who established a reputation for himself defending Native Americans in the Southwest. In 1931, 2 years after Houston took over, Howard won full accreditation as a law school. But more than that, under Houston, Howard became a laboratory for civil rights law. It became also a clearinghouse for civil rights cases. Lawyers sent records of litigation, briefs, to Howard to get advice or just to keep records. In 1935, Houston joined the NAACP. He left Howard Law School in the capable hands of his cousin, William Hastie, and at the NAACP, Houston refined the Margold Report. He didn't want only to stress the equal part of the separate but equal equation, but he had the idea that it would be wiser to focus on graduate and professional schools. Remember, when you bring a lawsuit, the burden of proof is on the person bringing the suit. So you have to prove whatever it is you're asserting. Well, if you want to prove inequality, it's difficult in education. You might say, well, they pay white teachers more than black teachers. You might say they fund the black schools better, and that may well be true. But does that mean there's a difference in education? When you think about it, in every city in America today, there are Catholic schools that spend a fraction per pupil of what the public schools spend, and the Catholic school graduates go on to college, and the public school graduates don't. They don't finish high school in most cases. Many go to jail. So is money really the sole determinant of a good education? So what Houston suggested was focus on graduate and professional schools because it was easy to prove legal inequality. Every southern state had a medical school for whites. None had a medical school for blacks. Well, unless you count Tennessee. Every southern state had a law school. None had for whites. None had a law school for blacks. So it was very easy to make a legal case for inequality. The first case that was brought to the NAACP was one they didn't go out looking for, was the case of Thomas Hocutt. It was brought by lawyers in Durham, North Carolina, who had ties to the Howard University Law School. Hocutt was a student, a graduate of North Carolina College for Negroes in Durham, and he applied to the pharmacy school at the University of North Carolina, Chapel Hill. He did so because it was the only pharmacy school in the state. There was no pharmacy school for black students. But the case was something of a disaster. Dr. James Shepard, the president of North Carolina College for Negroes, withheld a recommendation, and he also wouldn't send a transcript. He was afraid that the legislature would come down on his school like a ton of bricks if he took part in this case. And in court, it hurt that he didn't have a transcript or a recommendation from his college, but he also apparently had done pretty badly in high school, and he performed very poorly on the stand. And I don't think anyone that I've ever read has determined whether it was because he was just nervous or he really just wasn't very skilled or educated. But North Carolina argued, look, the guy's not qualified. Where's the evidence that he's qualified to be admitted to UNC? And the court agreed. They said, it's on, the burden of proof is on the plaintiff. You haven't proved that you have standing to be admitted to the University of North Carolina, so they never had to deal with the issue of race. This made an important point to Houston and his team at the NAACP. You needed to find a good plaintiff. They didn't have the resources to go out and lose cases. And they certainly didn't want to go out and get a set of bad precedents. They didn't want to waste what resources they had on cases they had little chance of winning. So they were very careful after that about selecting the plaintiffs. Ultimately, the implementation of this strategy fell to Houston's prize student, Thurgood Marshall, whom many of you may know later on in his career as a Supreme Court Justice. Marshall was born in 1907, a product of middle-class black Baltimore. His father was the head steward at the exclusive Chesapeake Bay Boat Club. His mother was a school teacher. Both of his parents were half white, and so Marshall grew up as part of the mulatto aristocracy of Baltimore. His family lived in Druid Hill Park in middle-class comfort. His brother became a physician, a chest surgeon, and Thurgood Marshall attended local high school, Lincoln College in Pennsylvania, which was known as the Black Princeton, partly because it was founded by Princeton graduates, but also because Howard was the Black Harvard, Morgan State was the Black Yale, and Lincoln was known as the Black Princeton. He decided to go to law school. He couldn't go to the University of Maryland because that was for whites only, so he chose Howard. Marshall had been an indifferent student at best at Lincoln. He was quite the party guy. He was, I guess today we call him kind of a frat boy. But at Howard, under Houston, he really blossomed as a student. He turned down a scholarship for postgraduate work at Harvard because he wanted to practice. And he began not only a legal practice, but doing work for the NAACP branch in Baltimore. And in one of his early cases, with the aid of his mentor, Charles Hamilton Houston, he got a black student named Donald Murray, a graduate of Amherst, a member of a prominent black family in Baltimore, admitted to the University of Maryland Law School. By the mid-30s, Marshall was functioning as Houston's assistant, and he joined the NAACP full-time in 1936. The first major victory for this strategy, for Houston's strategy, came in 1938 in the case of Missouri ex rel. Gaines versus Canada. Lloyd Gaines was a graduate of Lincoln University, Missouri's black university, and he applied for admission at the University of Missouri Law School. The state didn't have a black law school, but they had what was called an out-of-state tuition plan. Any black student who was qualified and could get into any of the surrounding states that accepted black students, Kansas, Illinois, and so on, Missouri would actually pay for that student to go to law school out of state as long as they didn't go to the University of Missouri. Gaines declined to take part in that out-of-state tuition plan. He said, look, I want to practice in Missouri. It would be an advantage to go to the University of Missouri Law School. The NAACP took his case to court, and the Supreme Court ruled in favor of Gaines. Chief Justice Hughes wrote that the limited demand for a legal education among the state's African Americans did not justify shifting the burden of providing an equal educational opportunity to other states. And equality, he argued, was the only basis on which separation was defensible. So Gaines was ordered admitted to the University of Missouri Law School. He never attended. He disappeared without a trace. Nobody knows to this day whatever happened to him. He vanished from the face of the earth. After Gaines, Houston, who had performed brilliantly in the case, was physically drained. He wasn't well, and he returned to private practice, although he continued to consult with the NAACP and maintain close ties to the Howard Law School. He turned over the legal affairs of the NAACP to Marshall, who was 30 years old at the time. There couldn't be really two more different figures than Charles Houston and Thurgood Marshall. Houston was a legal scholar, a legal philosopher of some standing. Marshall was a courtroom lawyer. That's what Houston had trained him to be. Houston was private, reserved, deeply intellectual. Marshall was an extrovert, not intellectual, but bright, clever. In 1939, the NAACP moved Marshall's operation out of the parent organization and created the NAACP Legal Defense Fund, Incorporated, which is sometimes called the Inc. Fund and sometimes called LDF. The reason it was made separate was the NAACP engaged in lobbying, so they weren't entitled to a tax exemption, whereas the Legal Defense Fund simply provided legal aid, and they were, so for tax reasons, they moved Marshall out of the parent organization. And Marshall really did prove to be ideal for this new job. He was a brilliant lawyer, a powerful advocate. He wasn't a great justice, and I think the two go together. He was an advocate. He was trained to be an advocate. He wasn't a balancer. He was brilliant at taking an argument and arguing it all the way through to its logical conclusion. He maintained close ties with his former professors at Howard. He knew his own limits as a writer of legal briefs. He said, I've never hesitated to pick other people's brains I don't have. He loved to share a drink with people. He liked to tell stories. He was a wonderful after-dinner speaker. He could speak the language of the people, something that Houston either couldn't or wouldn't do. And Marshall was physically courageous. He drove through the South, appeared in backwoods courthouses where the last black lawyer would often been run out of town on a rail or tarred and feathered. Marshall himself told a story about one of his travels through the South where he was on a train and it stopped in a small town in Mississippi, and he stood on the platform contemplating just staying overnight in that town when a small man with a gun on his hip came up to Marshall, and according to Marshall said, "Nigga, I thought you ought to know the sun didn't ever set on a nigger in this town." And Marshall said, "So I wrapped my constitutional rights in cellophane, tucked them in my hip pocket, and caught the next train the hell out of there." Gaines was an important victory, but it really didn't have much impact. One black student was ordered admitted to the University of Missouri's law school, and he never got to attend. But World War II intervened not long after that, and World War II had enormous impact. It brought really profound changes to America. You have to realize that during the Second World War, the military remained segregated. Black units fought mostly in rear echelon capacities. They were stevedores and teamsters, engineering battalions, which meant they dug ditches. Relatively few were combat units. But the draft was more equitable than it had been during World War I. African Americans served in the Marines, which had never happened before, in the Air Corps. And serving in the military gave black soldiers and sailors and Marines a sense of status. They fought for freedom in Europe and the Pacific, and they wanted freedom when they returned home. There was another force at work during World War II as well. Fighting a war against Nazi racism made America re-examine some of its own racial attitudes. And perhaps even more important than military service was the acceleration of a long-term trend, the black migration from the South to the cities of the Northeast and the Midwest. In the North, African Americans could vote, something they couldn't do in the South. What's more, residential discrimination concentrated the black population. Blacks were only permitted to live in certain areas of cities, which meant you had a concentrated black population, which gave them enormous political clout. They could elect aldermen, even members of state legislature, and even members of Congress. And so that was important. It gave African Americans greater political clout. It also was important in another sense. Sharecroppers never see a dime in cash in the course of an entire year. The whole system is kept on the books. The reason it emerged was, how do you create an economic system with no cash, which is the case in the South after the Civil War. But industrial workers in the North were paid wages. World War II was the making of the black working class. And it meant that there were a whole lot of black workers now who had cash and money, and they could contribute a little bit of it to black self-help organizations like the NAACP or the National Urban League. There was another effect of World War II, and that was the GI Bill. Black veterans were eligible. And the GI Bill paid for college, graduate school, professional school. It provided a stipend, a living allowance. And the demand was great. But when you looked around, the opportunities in graduate and professional school for blacks in the South wasn't that great. There were only 2 black medical schools south of the Mason-Dixon line, Howard University and Meharry. There was no accredited black engineering school in the South, and there was no institution in the South at which black students could pursue a PhD. There were along with these changes came legal changes. In Smith versus Allwright, the Supreme Court struck down the Texas white primary. That was in 1944, during the war. The Texas Democratic Party had organized itself as a private club and said, well, we can choose anybody we want, so we're not going to admit blacks. And so they couldn't vote in the primaries. Well, in the South, the Democratic primary was the election. The Republicans at most ran token opposition. And so the Supreme Court ruled that this exercise, this primary, was state action. The state ran the primaries, counted the ballots, and so therefore it couldn't discriminate on the basis of race. 4 years later, in Shelley versus Kramer, the Supreme Court they didn't actually strike down, but they held unenforceable restrictive covenants. Restrictive covenants were papers signed, a covenant signed when you bought a house saying, I will not sell to blacks, Jews, Puerto Ricans, whoever else they were trying to keep out of the neighborhood. And in Shelley versus Kramer, the Supreme Court said, yeah, you can go ahead and sign that, but you can't sue to enforce it. You can't use the machinery of the state to enforce it, which effectively rendered the restrictive covenants unenforceable. The big development came in terms of education in 1948 with the case of Sippuel versus the Board of Regents. Ada Lois Sippuel was a 21-year-old daughter of a clergyman with an excellent record at Langston, which is the Oklahoma College for Negroes, and she applied to the University of Oklahoma Law School. Oklahoma had a white law school, but none for blacks. Oklahoma also had a constitutional provision requiring separate education for the races. But the state had a law school for whites and none for blacks. But Oklahoma offered an out-of-state tuition plan, but under Gaines, that was not going to be the answer. So the state opened a fly-by-night law school for black students, a faculty of 3 white attorneys, 3 classrooms with access to the law library at the Capitol. Scipio declined to go to that law school. And the Supreme Court ruled that the state needed to provide her with an educational opportunity as soon as it did students of other races. They didn't deal with the issue of equality. They didn't deal with the issue of whether this fly-by-night law school was really the equal of the University of Oklahoma. Oklahoma couldn't get the thing up and running in time for the next semester. And they said, look, you've got white people going to law school, you've got to have an opportunity for blacks. And eventually, Scipio was admitted to the University of Oklahoma Law School, graduated in 1951. And some of you may have noticed back, it was about 8 or 9 years ago in the mid-90s, Ada Scipio became a member of the Oklahoma Board of Regents. With the development of the Cold War in the late 40s, discrimination proved embarrassing to the United States. You often hear, well, the Cold War and anti-communism hurt the civil rights movement. In some ways it did. It was easy for Southerners to accuse civil rights activists of being communist or communist influenced. But in fact, in many ways, the Cold War proved to be an enormous assistance to the civil rights movement. Soviet propaganda used American discrimination against the United States. With decolonization, discrimination hurt America with what were then called emerging nations, the new nations that came out of colonialism. And so all of this provided an impetus to deal with America's racial problem. These forces combined to lead to 2 enormous victories in court in 1950. 2 cases, Sweatt versus Painter and McLaurin versus Oklahoma. In Sweatt versus Painter, there's an interesting situation. Heman Sweatt, a postal worker from Houston, applied to the University of Texas Law School. He wanted to begin attending in the February 1946 term. Texas the state constitution of Texas required segregation at the University of Texas, and so he was denied admission. Thurgood Marshall filed for a writ of mandamus. A mandamus is an order by a court to an official to perform an act which his office requires him to perform. It's kind of an elaborate legalism, but Marshall's point was, you don't have a black law school, you have a duty to admit him to the University of Texas. Well, the Texas District Court ruled that the absence of a black law school violated the 14th Amendment, and it gave the state 6 months to come up with a black law school. Remember, this is 46, it's before the Scipio decision. So Marshall appealed to the Texas Court of Civil Appeals. Meanwhile, the Texas legislature, these people weren't stupid, saw the writing on the wall and appropriated $3 million to create what they described as a first-class state university for Negroes. And $100,000 of that money was to go immediately to the creation of a new law school in Houston. And in the meantime, they set up an interim law school for blacks in Austin. It was set up in rooms in a building about 8 blocks from the University of Texas. It had 4 faculty who were first-year instructors at Texas, and a library of 10,000 books, at least in theory. They put in orders for 10,000, they didn't have them yet. And Sweatt refused admission. The Texas Court of Civil Appeals said, we gave them a chance and they're setting one up. This is going to be a real law school. That's where you should go. So Marshall appealed to the Supreme Court. The Supreme Court decision is fascinating. It compared the 2 law schools. University of Texas, one of the nation's great law schools. One of the Supreme Court justices, Tom Clark, attended the University of Texas. Justices hired law clerks out of the University of Texas. Nobody was hiring law clerks out of this new fly-by-night law school for blacks. The University of Texas had 65,000 volumes. The black school had 10,000 on order, many of which hadn't arrived. The new law school was not the new law school that they were setting up was more impressive, but it still wasn't equal. The court wrote, we cannot find substantial equality in tangible factors. But more important, they said, were intangible factors, as Vincent put it, which make for greatness in a law school. He said, no one faced with the choice between these 2 law schools would choose the black law school. And so Sweatt was ordered admitted to the University of Texas. That decision showed just how brilliant Houston's strategy was. Not only focusing on graduate and professional schools, where it was easy to prove inequality, but on law schools, because you could take the next step. Supreme Court justices know the difference between a great law school like Texas and a fly-by-night job. They hire their clerks out of the best law schools, not out of fly-by-night law schools. And so it was a brilliant way to appeal to the justices. But it's important also to realize that this decision did not overturn Plessy. It made it awfully difficult to maintain separate but equal, because how do you create a truly separate but equal law school for black students when intangible factors would include the placement of the alumni and the prestige of the alumni and so on. But it was still theoretically possible. That same day, the court handed down a decision in McLaurin versus Oklahoma. George McLaurin applied for a PhD program in education at the University of Oklahoma. He had a master's degree. He was, as the lawyers put it, morally and scholastically qualified. But Oklahoma had a law that made it a criminal offense to educate blacks and whites at the same institution. So Oklahoma denied him admission, even though there was no PhD program in education for blacks in Oklahoma. A three-judge panel, three-judge federal panel ordered McLaurin admitted to the University of Oklahoma. And Oklahoma followed the court order, but they admitted him, as they put it, on a segregated basis. He couldn't sit in the classroom with other students. He had to sit in a little anteroom alongside the classroom. When he went to the library, he had to use a table at the mezzanine, on the mezzanine floor that was assigned to him and him alone. And when he ate, he could eat at the cafeteria, but he had to eat at a separate table for blacks only, and he had to eat at a different time from all other students. Well, Marshall challenged these restrictions in court. In the meantime, Oklahoma, worried about what might happen in court, modified his conditions. They allowed him to sit in the classroom, although in a row for colored students only. Of course, he was the only colored student. He was allowed to have his own table in the dining hall, but he could eat at the other time, or he had to have his own table, but he was allowed to eat at the same time as other students, and he was allowed a table that was for colored students only, but on the main floor of the library. The Supreme Court ruled that such regulations, quote, set McLaurin apart from other students. I think that's fair to say. And therefore, it impaired his ability to study, to exchange views with other students, and in general, as they put it, to learn his profession. The state had argued that, we could take these away. It doesn't mean white students are going to want to associate with him. It doesn't mean white students will sit next to him. But the court said there's a big difference between state-ordered discrimination and someone being snubbed by his social peers. Well, McLaurin and Sweat did not reverse Plessy, but it made it pretty difficult and very expensive for southern states to maintain segregation. And the NAACP lawyers kind of taunted the Oklahoma lawyers because law school was one thing. You could come up with a black law school. You might be able to come up with a black PhD program in education. But what about medical schools? You're going to create a separate but equal medical school? And Oklahoma had one program. It was the only school in the entire country that had a program more expensive than medical school. And that was their petroleum engineering program in Oklahoma. And they were talking, well, petroleum engineering is next. You guys want to set up a separate but equal petroleum engineering school. The question was, how much did the South, and how much could the South afford to pay to maintain segregation? Well, these victories were achieved by Houston's strategy of holding the South accountable to the equal part of separate but equal, focusing on graduate and professional schools. But ironically, Houston never lived to see these victories. He died of a heart attack just before the Supreme Court handed down its decisions in Sweat McLaurin. He was 54 years old. In spite of all of this, Sweat McLaurin involved only a small number of students. And after those decisions, the NAACP turned their attention to public schools, and very haltingly to the issue of separate but equal itself. Marshall later said that if the southern states had showed any willingness to reach any accommodation, the NAACP might have backed off. But Southerners showed no such inclination, and that forced Marshall and the NAACP to seek a decision overturning Plessy. So they filed suits in 5 carefully selected places: 4 states, South Carolina, Kansas, Delaware, and Virginia, and Washington, D.C. In the states, they argued that segregation violated the Equal Protection Clause of the 14th Amendment. In Washington, D.C., they argued that it violated the Due Process Clause of the 5th Amendment. The first case to reach the Supreme Court came from Clarendon County, South Carolina, where in 1951, a 3-judge federal court directed school officials to equalize their schools within 6 months. South Carolina was worried about what might happen. James Burns, once a Supreme Court justice, was governor, and he convinced the legislature to put $75 million into black education to equalize it. They were really serious about holding on to segregation. In January of 1952, the Supreme Court refused to take the case until the lower court had a chance to receive the report after 6 months. But in the fall of 1962, Clarendon County was back before the Supreme Court, now joined by the cases from Delaware, Virginia, Kansas, and Washington. On June 8, 1953, the Supreme Court said they weren't going to decide the case. They wanted to hear re-argument the following fall on 5 questions. And those questions dealt with the intent of the framers of the 14th Amendment. Did the 14th Amendment intend to prohibit segregated public schools? They wanted to hear argument about the power of Congress to abolish segregation, about the power of the court to abolish segregation, and they wanted to hear argument about what kind of remedy the court could order. Normally, when a court hands down a decision, they hand down what lawyers call a remedy, a fix. What are we going to do about it? And they said, well, do we have to fix this right away, or can we order a gradual process of relief? As the court prepared for the fall 1953 term and to hear these arguments, the Chief Justice, Fred Vinson, died. And this was terribly important in the evolution of the Brown decision. When Truman appointed his old friend to be Chief Justice, Vinson became the Chief Justice of a very divided court. Personal and ideological divisions had split the court into 2 warring camps, one led by Felix Frankfurter and Robert Jackson, which believed in judicial restraint, and the other led by William O. Douglas and Hugo Black, which believed in judicial activism. These ideological divisions had become intensely personal, and the feud between Jackson and Black was particularly bitter, and it even spilled over into the public. To make matters worse, Truman's 4 appointments, Vinson, Sherman Minton, Tom Clark, and Harold Burton, were about the worst set of appointments in the history of the Supreme Court. There wasn't anything that even rose to the level of mediocrity in the entire group. And Vinson was a weak Chief Justice and dominated by the much brighter figures, Black, Douglas, Frankfurter, Jackson, who were the intense partisans in this warfare. But Fred Vinson died going into the 1953 term. On hearing of Vinson's death, Felix Frankfurter said, "This is the first indication I've ever had that there is a God." Eisenhower appointed Earl Warren to replace him. Warren had a reputation as a tough prosecutor in California. He'd been a progressive Republican governor. One blot on his record as a civil libertarian was his support for internment of Japanese Americans during the Second World War. The appointment of Warren would be absolutely crucial to achieving a decision striking down segregation. There were still divisions. Frankfurter was worried about judicial activism. Jackson had reservations. Roberts had reservations. Warren lobbied them, talked to them. Warren was a brilliant politician and achieved the unanimous decision, which he wrote himself and was handed down on May 17, 1954, as you heard, just about 50 years ago this past Monday. The decision acknowledged that despite the extensive arguments regarding the 14th Amendment, the evidence was inconclusive. That was probably generous. The same Congress that passed the 14th Amendment appropriated money for segregated public schools in Washington, D.C. It's kind of hard, given that, to make a case that they intended the 14th Amendment to abolish segregated public schools. But Warren correctly pointed out that separate but equal didn't appear until Plessy versus Ferguson, and that education had changed between the 1890s and the 1950s. Education by the 1950s, he wrote, is perhaps the most important function of state and local government. The question the court faced was, did segregation by race deny equal educational opportunities even if the physical facilities were equal? Warren wrote, "We believe it does." He said the decision in Sweatt relied on intangibles, and segregation, he argued, generated feelings of inferiority. He said whatever the psychological knowledge at the time of Plessy, modern authority supports it. And that's where the famous footnote 11 occurred, in which he cited a whole bunch of sociological and psychological texts, no law whatsoever. He concluded, in the field of public education, separate is inherently unequal, and therefore violated the 14th Amendment. Since the cases were class actions, class action means it applied to more than just the individual parties to the suit. The forming decrees deciding the actual cases presented problems, as he put it, of considerable complexity. That too was an understatement. And so the court decided not to order a remedy at all. They said, why don't we want all the lawyers for all the sides to come back next term and tell us how we should implement this. We've decided segregation is unconstitutional. It violates the Equal Protection Clause. How should we go about fixing this? And they invited the Attorney General of the United States, who'd entered the case on the side of the NAACP, to come back. They also invited the Attorneys General of all southern states that either required or permitted segregation, because they wanted them to be part of this discussion. On the same day that they handed down Brown, they handed down a separate decision on public schools in Washington, D.C. Remember, the 14th Amendment applied only to states. It said, no state shall deny any person equal protection laws. So they had to decide Washington, D.C., and they went through a whole bunch of gymnastics to show how discrimination could be so unjust that it violated due process. And then they just finally admitted what they really meant, which was they said that earlier today we struck down segregated public schools in the states. You can't imagine the Constitution requires less of the federal government. Well, 1 year after that, on May 31st, 1955, the Supreme Court handed down its second ruling in Brown 2, as it came to be known. It restated that segregated public schools violated the Constitution. It concluded that the cases presented a wide variety of local situations and therefore required local solutions. And they remanded the case to the lower courts. But they did give some guidance. They said the lower court should be guided by what they called equitable principles. That doesn't mean quite what you think it does. It means be guided by equity law rather than common law, which allows a certain degree of flexibility. The plaintiffs, though, the black school children, they said, had personal and present rights to non-segregated education. A personal and present right is a right that goes away if it's not granted immediately. It doesn't do any good to give a 25-year-old a right to a non-segregated public education if he graduated at 18. So they said this is a personal and present right. And therefore, the courts below ought to require, quote, a prompt and reasonable start toward full compliance. Once that start was made, the school boards could ask for additional time, but only to handle logistical problems. And then they ordered the courts below to enter decrees necessary to admit the plaintiffs, the black school children, to public schools on a non-discriminatory basis, quote, with all deliberate speed. Well, as you all probably know, there was a good deal more deliberation than speed in the years that followed. There was a long, so when you look at this, I think you see two things. You see a long and tortured route for segregation to become inherently unequal. And it would be a long and difficult road in an effort to make Brown, the promise of Brown, a reality. It's a road, obviously, we're still traveling. I want to go back, as I conclude here, to the lone dissenter in Plessy, John Marshall Harlan, a former slave owner, the only dissenting vote in Plessy versus Ferguson. Harlan wrote, in view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among its citizens. In respect of civil rights, all citizens are equal before the law. I think it would be a good thing for us to contemplate those words as we mark the 50th anniversary of the decision that elevated Harlan's dissent into the law of the land. Thanks very much. And if anybody has questions, I'll be glad to take them. Yeah.
What were the numbers roughly that you were talking about in the southern states after the Civil War? That is, obviously they varied, but is there kind of was there a 2/3 black and 1/3 white? Or?
Oh, no. It varied enormously from place to place, but there were black majorities only in some areas of the Deep South, where blacks were a majority in no state except maybe South Carolina. If you look at the populations of the Deep South states, they're divided along the north-south axis. Northern Alabama has relatively small black population. It's poor soil. You couldn't have big plantations there. South, you got about half an hour by car now south of Tuscaloosa. You're into the Black Belt where there's dense black population. Same thing's true in Mississippi and Louisiana. Southern parts of the state have dense black populations. The northern parts have very sparse populations. On the East Coast states, black populations tended to be concentrated in the eastern part of the state. North Carolina, eastern North Carolina was plantation country. The Piedmont was smaller holdings, and the western part of the state was mountain and had virtually no slaves. So South Carolina is the one state which in the 1860s may have had a black majority, but that's, by the 1860s, I don't even think South Carolina had a black majority, and certainly no other state. Does that answer your question? Yeah.
I'm curious, you mentioned Plessy and the one dissenting vote. What was the makeup of that Supreme Court? Those nine justices, were there more Northerners?
Oh, far more Northerners, and in fact, the only dissenter was a Southerner. Harlan was a former slave owner who dissented in Plessy. Plessy's an interesting case because nobody thought it was a big deal at the time. If they did, they wouldn't have given it to Henry Brown, who was one of the dimmest bulbs who ever served on the Supreme Court. They gave it to a real non-entity because nobody thought it was a big deal. It was kind of a slam dunk, and who really cared that much about it. It became a very big deal as subsequent cases referred to it. But at the time, nobody really thought this was a big landmark. I mean, if they had, there were lots better justices they could have given it to than Henry Brown. And anybody thought this was going to be the law of the land for 50 years, they would have at least given it to somebody who could have written a better decision, arguing the same point of view. And again, it wasn't that Brown's conclusion was different. There were 8 justices on his side, counting Brown. There were 7 other justices. There was only one dissenter, but the decision itself is something of a mess, and it's quite badly written, and it's very, very long. And some of the other justices could have done a better job. It wasn't a Southern-dominated Supreme Court that decided Plessy. And as I said, the one Southern and the only former slaveholder was the one dissenter.
Do you think the justices from the North were of that mindset that you mentioned, kind of sympathizing with the South because of that influx of immigrants?
Yeah, I think so. And also, again, it's time for African Americans in the South to stand on their own 2 feet. They've been wards of the government for a generation. I think there was some of that attitude. There were a number of things that went into it. There was also the issue of states' rights and the right of a state to organize its own internal society, the police power of the state, which is really what the case turned on. Again, Brown did not say separate but equal. He said this is a reasonable exercise of the state's police power. If the state wants to do that, they can do that. And again, this was only on intrastate rail travel. If it went across state lines, that was something that Congress had a right to legislate, not the states, and so that wouldn't have applied. Yeah.
Michael, I was very much surprised. I was very much surprised recently to hear that Dwight Eisenhower was really very much disappointed in Earl Warren after he had appointed him as Supreme Court Chief Justice. I wonder if you could add a little bit.
Yeah, I could. I've written a fair bit about that. In fact, he was, but not because of Brown. He's often quoted. Steve Ambrose quotes him as having said Earl Warren was the biggest mistake he made. He never said that. There's no evidence whatsoever he ever said that. I've tried to track it down. I talked to Eisenhower's Attorney General, Herbert Brownell, who denied that he ever said or thought that. Brownell was closer to Eisenhower, especially on these issues, than anybody. There's no evidence in Eisenhower's papers. In fact, quite the contrary. He told Jim Hagerty in 1956, this is 2 years after Brown, when Eisenhower was contemplating not running for re-election. Hagerty was mentioning some people who might be possible Republican standard bearers, and he named Earl Warren, and Eisenhower said no, he wants to be one of the great Chief Justices, and he's well on his way to becoming one. So it certainly is no indication that he was upset with him, and certainly not over Brown, although Eisenhower wasn't thrilled about Brown. He didn't like the judicial activism involved in Brown, and he didn't much like the exertion of federal authority over states' internal affairs. He did become disillusioned with Warren, mostly over the so-called Red Monday cases. The cases where the court, Jenks and Yates, where the court struck down some of the congressional investigating powers and reined in congressional investigations in the mid-50s. Jenks and Yates were 56. And Eisenhower thought that he didn't understand those. He thought those had gone too far. And he came to disagree with Warren. Warren, for his part, was convinced that Eisenhower was mad at him, and mad at him over Brown, and made that statement several times in his memoirs. The best evidence that I've seen seems to be that Warren became alienated because he thought Eisenhower was mad at him, particularly over Brown. There's no evidence for that actually having happened, although eventually Eisenhower did did become disillusioned with some of the decisions. But again, those were the Red Monday decisions, not the three cases they decided on Monday in '56, not the Brown decision or subsequent desegregation decisions like Little Rock. Yeah.
I have an acquaintance here in Missoula who would be in her 50s now, and she was growing up in Mississippi with a white mother and a father who was half Cherokee. And for reasons that I don't know or understand, the father became a target of what she called the Klan in Mississippi, and her family fled on what was almost like a black underground railway from Mississippi all the way across the south to Arizona. That was in 1956, and I was just kind of staggered by the power of the Klan, which I had thought had been reduced by that time. Obviously, had not in her case.
You know, the Klan comes and goes. The Klan of the 1920s, which people mostly know about, is not the Klan of Reconstruction that had been stamped out by the federal government. The Klan of the 1920s was a variety of things. It was anti-black for the most part in the South, but it was strong in places like Indiana, where it was mostly anti-Catholic and anti-immigrant, not anti-black. Almost all of the Klan violence in the Southwest in the 1920s was directed against violators of Prohibition. The Klan was sort of anti-modern, anti-modernist. It died out after the Klan's own violence and some scandals involving Stevenson, the Grand Wizard of Indiana, came out in the mid-1920s, and it sort of receded, I guess, until Brown and other things in the mid-50s reactivated it in some areas.
I was wondering that.
Yeah. The challenge to segregation created a sometimes violent response. Schools were blown up in Clinton, Tennessee. There were riots in Hoxie. There was a famous incident in Little Rock where Eisenhower had to nationalize the Arkansas Guard and send in the 101st Airborne to secure the admission of 9 black students to Little Rock Central High School. The only thing that doesn't quite ring right about your friend's story. You wouldn't need an underground railroad. They had railroads and automobiles in the 1950s and highways
I
and things.
didn't mean to. I was using that figuratively. It was just they moved from black family to black family to black family. There wasn't any organized.
Yeah, there was a state commission in Mississippi, the records of which have only recently, in the last 5 years or so, been opened. Which really is a remarkable scandal because people assume that the Klan are these knuckle-dragging thugs and so on, and most of them were. It wasn't until 1968 when the court decided, Green versus Board of Education, that the court really took a more active role. Because it was easy to say in the late 50s that what Brown required was an end to segregation. It did not require integration. It said you have to stop segregating. And that may or may not produce integrated schools. In the South, it's much more likely to than in the North because the Southern residential patterns are less segregated than Northern residential patterns. But in 1968, the court ruled that the school boards had an affirmative duty to rip up segregation, as they put it, root and branch. And that was really the beginning of the end of segregation in the South. And for the most part, the Civil Rights Act of '64, the Voting Rights Act of '65 were very effective in doing that. In fact, I've taught in the South, and the South is less segregated in many ways today than the North. One of the most interesting examples is, first of all, kids go to school together, unlike Northern schools that are segregated by residential patterns. Because in the South, if you have a unified school district, you're going to have desegregation because black and whites live not necessarily in the same neighborhoods, house by house, but in neighborhood to neighborhood in proximity. It was a product of, it was convenience of the master and servant class to live closer to each other than in the North. And so they go to school together, they know each other, they play sports with each other, which is not necessarily true in the North. And the most dramatic example of that I noticed was when I taught at the University of Alabama. First of all, I was teaching on the campus where George Wallace stood in the doorway of Foster Hall in 1963 and said, segregation now, segregation forever. And there were black students around. But there were about the same percentage of black students that were at the University of Illinois. The difference is In Alabama, they sat scattered throughout the classroom. In Illinois, they always sat huddled together in a group in a corner, almost always in the back. Student life was far more segregated at the University of Illinois than it was at the University of Alabama in the 1980s. So part of it is I think the South had its catharsis. I mean, they had to confront this. The North, in some ways, never really had that. Had to come face to face with its own practices, its own racism, the consequences of its own actions. You know, we think of residential segregation as happening. Well, some of it happened because of restricted covenants, some of it happened because of federal lending policies, and there are a lot of reasons why residential segregation existed in the North. It's not all by choice or by accident. Anybody else?
Thank you.
That's it. Thank you.